Come to order. Clerk will call the roll.
Chair Flores,
Here.
Vice Chair Parker, Senator Hinojosa,
Present.
Senator Huffman,
Present.
Senator Miles, Senator King, Senator Hagenbu.
So a quorum is not established, and as members become present, we will establish a quorum. But in the meanwhile, we'll begin to hear bills, and so members, as we're near the close of our legislative session, this committee's made great progress to ensure that Texas is a safer place, and that what we have may be our final list of bills, but let's get to work, and we'll see. It's not over yet till it's over. And this is the intent. The chair laid out these bills one at a time, and if we have a quorum, we'll vote them out, and if we don't, we'll vote them out altogether like we did Tuesday. If you intend to provide verbal testimony, would like to register a position on one or more bills, please register at one of the kiosks located by the hearing room, or you can fill out a card. From members, are we ready to go? Chair lays out House Bill 75 by Huffman.
Thank you. Mr. Chairman, members, my office has received reports that magistrates have been indiscriminately making no probable cause determinations when the facts suggest that there is clearly probable cause to warrant an arrest. House Bill 75 requires a magistrate who determines that no probable cause exists to believe that a person committed an offense in which they are arrested to enter in the record written findings to support the determination. This provision was included in Section 1 of Senate Bill 9, which passed the Texas Senate with a 28-2 vote on February 19th. However, the House determined that this important provision was not germane to the bill, and thus we have decided to move it on its own. That's it.
With that, there's no one for invited testimony, so invited testimony is now closed. The chair now opens it for public testimony. There's no one registered for public testimony. Anyone wishing to speak on, for, or against House Bill 75? Hearing none, public testimony is closed, and we hold the bill pending. Chair calls House Bill 413 and recognizes Senator Huffman to explain the bill.
Thank you, Mr. Chairman. Members, pretrial detention is meant to ensure court appearances and public safety, not to serve as an unofficial sentence. When individuals are held longer than the legal penalty for their alleged crime, the system is effectively punishing them before they have even had their day in court. House Bill 413 ensures that a defendant charged with a Class B misdemeanor or higher category of offense is not detained in jail pending trial for a cumulative period that is longer than the maximum term of confinement on conviction of the offense. The bill exempts defendants who are being evaluated for competency or have had a court commitment order issued under Chapter 46B of the Code of Criminal Procedure. This measure will protect defendants unfairly impacted by court backlogs from violations of their fundamental rights to due process and protection against excessive punishment. I'm happy to have worked with Jolanda Jones and others for this reform.
Members, any questions? Hearing none, divided testimony on House Bill 413 is now open. There's no one registered, so invited testimony is closed. Chair now opens up for public testimony on House Bill 413. Chair sees no one registered. Is there anyone wishing to speak on, for, or against House Bill 413? Hearing none, public testimony is closed. Hold the bill pending. Show Senator Hagenbu as present. Chair lays out House Bill 1422 and recognizes Senator Huffman to explain the bill.
Thank you, Mr. Chairman and members. House Bill 1422 serves as a comprehensive set of reforms aimed at supporting survivors of sexual assault while strengthening the prosecution of serious sexual offenders. House Bill 1422 allows sexual assault survivors to have sexual assault examination kits tested by the Department of Public Safety for foreign DNA material without having to immediately file a police report, empowering more survivors to come forward when they are ready. The bill creates a first-degree felony offense for continuous sexual abuse of an adult. It adds this new offense to the list of crimes ineligible for probation. It also establishes a 25-year minimum sentence for aggravated sexual assault of a child under the age of 10, standardizing the age bracket with similar offenses. It gives judges the discretion to stack sentences for sexual assault charges, a power currently limited to offenses against minors. The bill also increases penalties for voyeurism, elevating the offense from a Class C to a Class A misdemeanor, and further enhancing it for repeat offenses and those involving child victims. Members, together these reforms strengthen accountability for sexual predators and offer survivors more autonomy, safety, and justice. This is a really great bill. Happy that Lacey Hull let me do
So
this.
Senator Miles is present. So any questions, members? If not, Chair opens up for invited testimony. Chair sees no one registered invited testimony on House Bill 1422. Invited testimony is now closed. Chair now opens for public testimony. Chair sees no one registered for public testimony on House Bill 1422. Is anyone here wishing to testify on, for, or against House Bill 1422? If not, public testimony is closed. We'll hold the bill pending. Chair lays out House Bill 2073 and recognizes Senator Huffman to explain the bill.
Thank you, Mr. Chairman and members. Currently, there is no specific penalty enhancement for violating family violence or sexual assault protective orders or bond conditions when the perpetrator possesses a deadly weapon. Enhancing these penalties would give law enforcement and prosecutors better tools to respond to these high-risk situations to protect the victims more effectively. House Bill 2073 protects victims by increasing penalties for violations of protected order or bond conditions in cases involving family violence, child abuse or neglect, sexual assault or abuse, indecent assault, stalking or trafficking when the offender is in possession of a deadly weapon. A first-time violation with a deadly weapon is upgraded from a Class A misdemeanor to a state jail felony. A repeated violation involving a deadly weapon is further enhanced from a third degree to a second-degree felony. House Bill 2073 increases accountability for individuals who violate protective orders while armed, reinforcing Texas's commitment to supporting survivors and ensuring that those who threaten, intimidate, or commit violence are prosecuted accordingly.
Members, any questions of the witness?
I'll be a
It's
witness.
been a long day. Yes, it's been
And it's
any
gonna be
questions-
longer.
Any questions for Senator Huffman? Hearing none, the chair now opens up for invited testimonies. Chair sees no one registered for invited testimony. Invited testimony is closed. Chair now opens for public testimony. Chair sees no one registered for public testimony. Is there anyone here wishing to testify on, for, or against House Bill 2073? Hearing none, public testimony is closed, and we'll hold the bill pending.
Yeah, I'm on a roll.
Chair recognizes Senator Huffman to explain House Bill 2573.
2593.
2593.
Thank you, Mr. Chairman and members. Members, current Texas law already reflects that children and the elderly and disabled are at a higher risk of exploitation, and that there is an increased likelihood that they are unable to protect themselves from harm. Accordingly, House Bill 2593 increases the penalty range for indecent assault against the elderly or disabled individuals from a misdemeanor to a second-degree felony. This penalty level will align the offense with indecency with a child by contact in recognition of the increased vulnerability of these populations.
Any questions, members? If not, the chair now opens up for invited testimony. There's no one registered for invited testimony. Invited testimony is closed. The chair now opens up for public testimony. Chair sees no one registered for public testimony. Is there anyone wishing to testify on, for, or against House Bill 2593? Hearing none, public testimony is closed. We'll hold the bill pending.
Thank you. Thank you, Mr. Chairman. And knock those out.
Chair lays out House Bill 108 and recognizes Senate sponsor Senator Hinojosa to explain the bill.
Thank you, Mr. Chairman. This is a bill by Representative Lisa relating to the use of body armor during the commission of a violent crime. In Texas, most civilians can legally purchase and wear body armor, such as bulletproof vests, without special permission or licenses. However, using it while committing a crime can lead to significant concerns for public safety. It not only signals an intent to resist or confront law enforcement, but as seen in past violent incidents, it can also escalate threats and impede an officer's ability to effectively intervene. We have witnessed such incidents here in Texas, like the 2023 mass shooting at the Allen Premium Outlets, where the assailant wore technical gear, including a ballistic vest, as he opened fire on innocent shoppers. Texas law already bars convicted felons from possessing body armor, and this bill builds upon that by strengthening consequences for misuse during serious offenses. House Bill 108 establishes an affirmative House Bill 108 establishes an affirmative finding process for the use of metal or body armor during the commission of a Title V third or second degree felony offense, mandating an automatic elevation of the offense to the next highest penalty classification upon conviction. It's important to emphasize that House Bill 108 does not restrict law-abiding Texans from owning or purchasing body armor. Instead, it targets those who exploit this legal protection during the commission of a violent crime. A floor amendment in the House added language to ensure this will not apply to peace officers, military members, and security officers using body armor.
Members, any questions? Any questions? If not, the chair now opens up for invited testimony. Chair sees no one registered for invited testimony. Invited testimony is now closed. Chair now opens for public testimony. There's no one registered for public testimony. Is anyone present wishing to testify on, for, or against House Bill 108? If not, seeing none, public testimony is closed. We hold the bill pending. Show Senator King is present. Chair lays out House Bill 3816, recognizes Senate sponsor Senator Zaffarino to explain the bill.
Thank you, Mr. Chairman. Mr. Chairman and members, House Bill 3816 is by Representative Will Metcalf. It was passed unanimously by the House. Relates to prosecution of the criminal offense of cruelty to livestock animals. Members, although cruelty to livestock animals is a criminal offense, the offense does not include administering controlled substances to them. In competitive horse racing, administering controlled substances such as fentanyl and cocaine has raised red flags among veterinarians, livestock regulators, and the Texas Racing Commission, as these substances can mask injuries or artificially enhance performance, putting the animals and their handlers at risk. Generally then, House Bill 3816 would expand the definition of cruelty to livestock animals to include administering a controlled substance unless the administration is done with a valid prescription or is ordered by a healthcare professional.
Any questions? If not, the chair now opens up for invited testimony. Chair calls Amy Cook and Kent Richardson. Amy Cook and Kent Richardson. Good afternoon. And we'll start from my right. You state your name, who you represent, and you begin your invited testimony.
Chair, members, my name is Kent Richardson. I work in the Criminal Prosecutions Division of the Attorney General's Office, and I'm here to offer any resource testimony that might be needed, and I'm able to answer on this bill as needed. So.
Thank you, members. Any questions? If not,
Good afternoon. I'm Amy Cook, the Executive Director of the Texas Racing Commission, and I'm here on the bill as a resource witness only.
thank you both for being here. Any questions, members? Not? Thank you for being here.
Thank you, Chair.
Chair sees no more invited testimony. Chair now opens up for public testimony. Chair sees no one registered in public testify on this bill. Is there anyone here who wishes to testify on, for, or against House Bill 3816? Hearing none, public testimony is closed, and we'll hold the bill pending.
Thank you, Mr. Chairman and members.
Chair lays out House Bill 2854 and recognizes its Senate sponsor, Senator West, which Senator Miles will represent Senator West, and to explain the bill.
Thank you, Mr. Chairman, members. House Bill 2854 requires parole officers to notify hospitals when a parolee has committed a violent offense visiting their premises. This bill comes out of a tragedy that took place in his district on October 22nd, 2022. A social worker and a nurse at Methodist Dallas Medical Center was killed by a violent offender out on parole for aggravated robbery prior to shooting the parolee. And violated his parole conditions over 50 times. Following the shooting, we learned that the individual had violated his parole just days before the fatal incident by going to Methodist Dallas Medical Center past his curfew for the birth of his child. After the birth of his child, the parolee's parole officer respectively agreed to modify his prearranged schedule and allow him to stay at the Methodist Dallas Medical Center. Not once during the process did the parole officer notify Methodist Dallas Medical Center law enforcement that there was a violent criminal in their midst, and this bill deals with the loophole by requiring notification to a hospital or a local law enforcement when the violent offender visits the premises. This bill applies only to parolees who are serving sentences for a violent offense and does not apply to visits where one receives medical treatment, including emergency medical care. And that is the layout for House Bill 2854.
Thank you, Senator. Any questions? If not, the chair now opens up for invited testimony. I see no one registered for invited testimony. Invited testimony is now closed. Chair now opens up for public testimony. I see no one registered for public testimony on House Bill 2854. Is there anyone here present to wish to testify on, for, or against House Bill 2854? Hearing none, public testimony is closed. We'll leave the bill pending. Chair lays out House Bill 1871 and recognizes the Senate sponsor, Senator Schwertner, to explain the bill.
Good afternoon, and thank you, Mr. Chairman and members. I appreciate the ability to bring this bill forward. Members, this bill seeks to provide a stronger deterrent to those who attempt to take the lives of peace officers acting in the line of duty. Currently, both attempted capital murder of a peace officer and aggravated assault against a public servant are punished as first-degree felonies, even though attempted capital murder of a peace officer requires a higher threshold of proof for prosecution. This bill increases the punishment related to attempted capital murder of a peace officer to reflect the seriousness of the crime and account for the relative difficulty to prove the case in court. Specifically, the bill establishes the punishment of this first-degree felony to include a range of being life or 25 to 99 years and makes an inmate ineligible for parole or mandatory supervision if serving a sentence for attempted capital murder of a police officer. This bill addresses a real-world situation encountered by the Brazos County community and Brazos County District Attorney Jarvis Parsons, who is present as an invited witness. Thank you, Mr. Chairman.
Any
Allow me to lay
questions
this out.
to Senator Schwertner? If not, the chair now will open for invited testimony. Calls up Jarvis Parsons. Good afternoon. Thanks for being here.
Good afternoon, Mr.
You
Chairman.
state your name, whom you represent, and you begin your testimony, please.
Thanks. Jarvis Parsons, Brazos County District Attorney, and I'm registering for the bill. Thanks. As a 23-year prosecutor who has seen almost every type of crime here in Texas, I am here today in support of HB 1871, which increases the penalties for attempted capital murder. Senator Schwertner is correct. This is a real-world situation that has happened in Brazos County, but also all across the state of Texas, where attempted capital murder and recklessly causing bodily injury of a peace officer are at the same exact level of offense. And I think that that's a change dealing with, especially concerning the mental state of a person whose specific intent is to murder a police officer in the course of their duties. We attempt to rectify this by doing a couple of things: increasing the punishment from a minimum of probation to a minimum of 25 years up to life in prison. And it denies parole for individuals convicted of attempted capital murder of a peace officer. So individuals who are sent to prison for trying to murder police officers stay there for their entire sentence given to them by a judge. I think it sends a strong message to our law enforcement who run towards danger as opposed to away from it on behalf of us as citizens, and it allows prosecutors a tool to go out and receive justice in that small amount of cases where individuals have every intent to make sure a police officer does not go home to their family at night after doing what they have been born to do, which is to protect our citizens here in Brazos County as well as the state of Texas. And I'm open to any questions that you may have.
Senator Hinojosa.
Thank you, Mr. Chairman. I guess I'm trying to really grasp what we're doing here as it relates to right now, what is the present sentence structure?
The present sentence structure is that a person who has specific intent to murder a police officer in the course of their duties, the punishment range is anywhere from probation up to life in prison. But to make it even clearer, a person who recklessly causes bodily injury to a police officer and it just exhibits a deadly weapon has the exact same punishment as a person whose sole goal was to murder a police officer and just does not complete it. And so that's where I believe the inequity is.
Okay, the parole up to life, and the bill how does it change that?
What it does is that for those individuals who have specific intent to murder a police officer in the course of their duties, that punishment then increases to a minimum of 25 years in prison. It also denies parole to that particular individual who has been shown that they have specific intent to murder police officers.
So the person would have to at least serve 25 years minimum?
Yes.
Okay, got it. Thank you.
Senator King.
Thank you. I'm sorry. I really appreciate what the bill's trying to do. I'm just trying to make sure I understand it. So if I'm a police officer and I'm shot and struck, I survived the shooting, then under current law, the shooter would be charged with?
The shooter could be charged anywhere between recklessly causing reckless aggravated assault on a peace officer or attempted capital murder.
And if they were convicted today of attempted capital murder, the sentencing range would be?
Probation up to life in prison or anywhere in between.
And it's classified as a first-degree felony?
Yes, sir.
All right. So if somebody shoots at me but doesn't hit me, what would the charge be?
The charge would be exactly the same. It could be anywhere from intentionally knowingly threatening a police officer and exhibiting a deadly weapon, and it could be charged as aggravated assault on a peace officer or attempted capital murder, but the punishment range would still start at probation.
All right. And so after the bill passes, then for shooting at me and missing, it's still going to be first degree attempted capital murder of a peace officer.
It could be.
But it would be a minimum 25-year sentence?
Yes, sir. The only difference is that the prosecutor can look at the unique facts and circumstances to see if this was reckless, knowing or intentional, or if they had specific intent to murder a police officer. So they could still go with the
lesser included offense, or?
They could. They could go with the lesser included offense if the facts warranted it, but they have the ability to go higher if the facts warranted as well.
Okay. And it would be the same charge if it happened within a penal institution, right? There wouldn't be any difference?
They could still, if it was a peace officer in a penal institution,
yeah.
Yes. If it was a peace officer in a penal institution.
Same attempted murder, okay. All right,
yes.
Thank you.
Any other questions, members? Thank you very much for being here.
Thank you all for having me.
Thank you, sir.
Chair sees no other invited testimony, so invited testimony is now closed. Chair now opens up for public testimony. Chair calls David Gonzalez. Good afternoon, sir. Your name, who you represent, your position on the bill, and you have 2 minutes.
David Gonzalez, the Texas Criminal Defense Lawyers Association, testifying in opposition of the bill. And the basis, as it relates to this conversation, is who makes that decision. Is it the jury or is it the prosecutor? There's 142 instances in published cases involving attempted capital murder of a peace officer. They fall within 3 categories. The first category are people that fire weapons and intentionally attempt to hurt or kill police officers. In Teeter versus State, person pointed a gun but didn't fire, and that was the jury giving him a 30-year sentence. State versus White, person stabbed an officer. The jury gives him 90 years. In Griffin, fired at a peace officer, life. The jury in Walker, 50 years when a gun was discharged. In Hamer, shot at officers, 75 years. In Gantz, 99 years when someone actually got hit. Those we don't have a dispute of. The jury's already giving those sentences the right amount of severity. It's in the two other categories. When juries are giving sentences of 15 years and 20 years, it's for brandishing but not firing. And we think that they are looking at the intent. But the more significant cases are when they involve vehicles. So, for example, in Moreno, where the jury gives 15 years, there was a dispute about whether someone was driving and did they swerve toward an officer. In those cases, that don't involve guns. Our concern is that right now the juries are listening to the evidence, they're making the decisions appropriately, and the 25 years minimum should apply to firearm cases, but not the other cases that don't involve the direct attempt to take a person's life.
Thank you for your testimony, Senator Hinojosa.
Just a real quick follow-up. So how do you distinguish between actually trying to kill a police officer as compared to someone that just you gave you have a certain number of examples of how do you distinguish that?
I think that's what juries do. In a lot of the cases that I've read or looked at, it's when people, in the most recent ones, they're actively saying things, where they're trying to do things, they're intentionally trying to have harm. The harder cases where I think the lawyers fight a lot is, well, how do you judge that intent, and how do juries figure that out?
So if a young person, for example, is stopped on the highway and then panics and takes off, it is possible and almost runs over the officer. Could that be under this new bill?
If that person's convicted, it's 25 to life, no parole, and you serve every day of that.
So that's I guess that's an example
Of our objection, yeah.
Okay. Thank you.
Chairman,
Senator King?
and forgive me for yapping so much, but so the one I'm kind of thinking here, and it happens every month somewhere, somebody gets pulled over or an officer walks up to the car and somehow the officer reaches in and the officer's getting drugged down the road and then rolls off the car. Maybe they've been pulling the guy out of the car at the time, and for whatever reason, or the guy pulled a gun and they're wrestling with it, or there's something and inevitably the person drives off and the officer stuck their clean to the vehicle and then lets go and rolls. So under this, could that be classified? I guess they're still going to have to prove up the elements of that it was criminal attempt, capital murder, as opposed to
Aggravated assault, I think.
aggravated assault or reckless conduct or something like
Yes,
that.
sir. Yeah, and I think our position as an organization is just that the juries are the best people to decide what that range of punishment should be, instead of it just always starting at 25 to life, because those circumstances may be different. Some of those cases involve disputes as to whether was the car in park or not, did it stay and drive. It's one thing when someone speeds off at a very high rate of speed versus the car is rolling. That's some of the published cases, but they're all very factually intensive, as Representative Hinojosa had talked about, or what are the circumstances. With body-worn cameras right now, there's so much evidence. We just ultimately think the juries do a very good job of figuring out what intent is, and they should get the full range of punishment to decide.
Okay, thank you.
Thank you.
Mr. Chairman, is there any way we can get the DA back to the table for a question?
Do you want me to move out?
You can stay. I want you to stay as well, please.
Mr. Parsons, thank you for coming back.
Thank you. Mr. Parsons, you heard the gentleman's testimony, his witnessing. Could you address those two issues that my colleagues and I have? One being, would you be opposed to this being limited to firearms? And just address what the two issues that he's brought up, because he's brought up some valid issues that obviously has got some concern for us up here.
Absolutely. I would be opposed to that because a knife can kill just as much as any other type of weapon. I think the other argument that is there is the fear of over-prosecution and a person doing something that is reckless, like driving with a police officer in the vehicle, would be overcharged. the thing that is good about this bill is that the lesser includeds of intentionally, knowingly, or recklessly causing bodily injury are still available with this bill. So it's an automatic lesser included because it's just a different level of mental state. So if a jury decides, because we agree that juries are very good at looking at nuance and looking at the facts, believes this is reckless or believes that this is knowing, then probation up to life in prison is still available to the defendant.
Okay.
The difference in this case is right now, if there is specific intent to murder an individual, a police officer in the course of their duties, it is still probation. And so it allows the jury the choice and the ability to say, no, this is the worst type of crime that could possibly happen, and the minimum be 25 or the minimum be probation. And it leaves the whole gamut still there because there's still a lesser included offense that the jury would still be able to consider.
So you're comfortable leaving it arbitrary to the jury because the incident, the scenario that Senator King gave you happens every day in every major city in every state in this country. That somebody gets drugged or an officer gets drugged off. So do you want to make that, do you understand you're leaving that door open?
I do understand what you're saying, Senator Miles. What I would say in that particular hypothetical is that we would never charge that as a attempted capital murder.
You
That's true.
wouldn't.
And if a prosecutor did not, or a prosecutor chose to do that, the jury still has the ability to say, no, we believe you, or we do not believe you. And they can go lower than that with a lesser included. So the jury still has the freedom. They are not locked in to any sort of punishment, even with this charge, because the defense attorney can still ask for a lesser included of to reckless, knowing, or intentional aggravated assault. And it's an automatic lesser included that can be given. And so they still have all of those freedoms, and the defense still has all of those protections.
I think leaving that door open gives us a little heartburn, a little bit. Thank you. Thank you. Thank you, Mr. Chairman.
Any questions, other questions? Thank you very much. Thank you both for being here.
Thank you all very much.
Chair sees no one else registered for public testimony. Does anyone else here present wish to testify on, for, or against House Bill 1871? Hearing none, public testimony is closed. We'll leave the bill pending. Ms. Open Alvarado ready? Show Vice Chair Parker as present. Chair lays out House Bill 3463 and recognizes Senate sponsor Senator Alvarado to explain the bill.
Well, I'd say good afternoon, but we're moving into the evening hours. Good evening, Mr. Chairman and members. We do have a committee substitute. And members, I apologize. We got the request for the committee substitute, some suggested language from the governor's office. We got that about 2 o'clock this afternoon, that request. So I'm sorry that we're just now getting this to y'all.
The chair lays out a committee substitute for House Bill 3463. Is there any objection? Hearing none, substitute is adopted. So
Thank
explain
you.
the bill and the substitute, please.
The committee substitute for House Bill 3463 by Representative Wally strengthens and clarifies the process for providing written notice in theft of service cases. It updates the acceptable methods of delivering notice to include email and text message, in addition to registered mail and commercial delivery service. The substitute removes the more ambiguous option of another form of written communication to ensure clearer and more consistent standards for how notices must be sent to the accused. The committee's substitute language change was requested by the governor's office, and we ask for your favorable consideration.
Any questions, members? Any questions? If not, the chair now opens for invited testimony. Chair sees no invited testimony registered. Chair now closes for invited testimony. Chair now opens for public testimony. Chair sees no one registered for public testimony. Is there anyone here present wish to testify on, for, or against House Bill 3463? Hearing none, public testimony is closed and we'll leave the bill pending.
Thank you.
More than 30 minutes. 30 minutes would be good. Chair lays out House Bill 2348 and recognizes Senate sponsor Senator Hagenbu to explain the bill.
The duty to protect elderly and disabled individuals who may be victims of key witnesses in criminal cases. These individuals often face significant challenges in providing testimony, including health concerns, mobility limitations, or the stress of courtroom proceedings. Ensuring that their testimony is preserved accurately and efficiently is critical to delivering justice and holding offenders accountable. Under current law, depositions of elderly or disabled witnesses may be taken in criminal cases, but there is not clear requirement for video recording of these testimonies. Without a visual record, important nonverbal cues, demeanor, and context can be lost, potentially weakening the impact of the testimony in court. House Bill 2348 amends current law and strengthens Texas's commitment to protecting vulnerable witnesses and ensuring fair trials by allowing the video recording of depositions for elderly or disabled individuals in criminal cases. It requires the individual operating the recording device to be able to testify regarding the authenticity of the video recording. It ensures video recordings are admissible in court, preserving the full context of the witness's testimony, including tone, demeanor, and physical expression. It modernizes Texas's legal process, allowing courts to adapt to needs of victims and witnesses to ensure justice is not delayed, that it is served effectively. Thank you, Mr. Chairman, members, for your consideration of this bill.
Members, any questions? Hearing none, the chair now opens for invited testimony. Chair sees no invited testimony registered. Invited testimony is now closed. Chair now opens up for public testimony. The chair calls Alicia Patterson. Alicia Patterson. Thank you for being here. Your name, who you represent, your position on the bill. You have 2 minutes.
Thank you, Chair Flores and committee members. My name is Alicia Patterson. I'm the Chief Elder Abuse Prosecutor in the Dallas County District Attorney's Office, and I'm here representing Dallas County District Attorney Judge John Cruzo in support of House Bill 2348. Elderly and disabled individuals are far too often the targets of crime. They deserve to have their voice heard in court, even if they can't physically be present in the courtroom, and this bill simply allows them to both be seen and heard. And I do want to point out that the rules of evidence are still in effect for a deposition. This is not an attempt to do anything other than memorialize testimony of elderly and disabled victims. It is both direct and cross-examination is memorialized in accordance with the rules of evidence, and I'm happy to answer any questions that you may have.
Thank you. Any questions, members? Mr. Hagenbu, you have any questions of this witness? Thank you very much for being here.
Thank you so much.
Thank you for your testimony.
Thank you.
Appreciate it.
The chair sees no other public witnesses, so anyone who wishes to testify on, for, or against House Bill 2348, hearing none, public testimony is closed and we'll leave the bill pending. So you guys Senator Creighton's bill? Chair lays out House Bill 2594 and recognizes the Senate's sponsor, Senator Creighton, and Vice Chair Parker would explain the bill.
Well, thank you, Mr. Chairman and members, for allowing me to lay out Senator Creighton's bill here. the committee substitute to House Bill 2594. Under current law, prosecutors face jurisdictional limitations that can hinder efforts to bring charges when cybercrime crosses county lines, especially when dealing with intangible personal property such as digital assets like cryptocurrency, online fraud, or intellectual property theft. The committee substitute to HB 2594 provides prosecutors with greater flexibility to pursue these crimes and seek justice on behalf of victims by updating our venue statute to allow for prosecution of these crimes in the county that 1, the victim resides in, that the defendant is apprehended in, or that 3, the defendant is extradited to. This change aligns with current Texas law, with other venue statutes and places for crimes such as fraudulent use of identifying information, debit card or credit card abuse, computer crimes, and financial data theft. The committee's substitute to 2594 will give our local prosecutors the tools they need to fight modern theft and cybercrime and ensure that victims of complex multi-jurisdictional theft cases are not left behind because of outdated venue statutes. Thank you, Mr. Chairman and members, for allowing me to lay out Senator Creighton's bill.
The chair sends up committee substitute for House Bill 2594. Any objections to adopting committee substitute? Hearing none, so ordered. Is there any questions, members? If not, the chair now opens for invited testimony. The chair calls Nancy Hebert. Good afternoon. Here's your name, who you represent, position on the bill, and you may begin your testimony.
My name is Nancy Hebert. I'm with the Montgomery County District Attorney's Office. I am here testifying in favor and for the bill, House Bill 2594. This is a bill that we think that is very important to be adopted, and there are really 3 major reasons why. First, it adopts law that is bringing it into the same realm that's needed with cybercrimes. Right now, cybercrimes move at the speed of light, and the problem is they can be done anywhere. They can be done on a mobile device, they can be done from a laptop, they can be done from an unknown location. And if a prosecutor can't prove venue, then it's impossible to bring that case. However, we have victims in our own counties that need to have these cases prosecuted. So what this bill allows is that the venue to be the county where the victim lives or where the defendant is apprehended, which means that it would be a convenient county for that defendant because that's where they are located. So what this bill allows for is to adopt the law to the realities of cyber electronic crimes. It also allows the trial to take place where the victims have been targeted, and it enhances the ability of prosecutors to obtain witnesses and the records that are needed at the time of trial because they are local records. And so that is why we ask for a favorable vote. It closes this void on venue where prosecution cannot occur because there's no county that can actually be established on where the offense originated. Thank you.
Thank you. Any questions, members? Thank you for being here.
You're welcome.
Chair sees
Thank you very much.
Chair sees no other invited testimony. Invited testimony is now closed. The chair now opens up for public testimony. There's no one registered for public testimony. Anyone here wishes to testify on, for, or against House Bill 2594? Hearing and seeing none, public testimony is closed and the bill will be left pending. Chair lays out House Bill 2761, recognizes Senator sponsor, Senator Parker, to explain the bill.
Well, thank you very much, Chairman Flores and members, and thank you for the opportunity to present House Bill 2761. This bill makes a necessary clarification in the law to ensure that perpetrators of trafficking and prostitution are held accountable. In 2018, Andrew Turley was found guilty of drugging his 4-year-old daughter. It's very hard, Mr. Chairman, to talk about this. This is so despicable that we have monsters like this in our society. But he was found guilty of drugging his 4-year-old daughter with a sleep aid and selling sexual contact with her. However, when the case went to the Texas Court of Appeals, he was not charged to the fullest extent of compelling prostitution because of 2 primary reasons. 1, the sexual encounter was stopped during the sting operation, thank God, and the arrest of Turley was made prior to completion of a sexual act. The child was medicated, secondly, with a sleep aid, allowing the defense to claim that she lacked the mental capacity to knowingly consent to the act. This is a 4-year-old baby girl. The Court of Appeals interpreted the current statute to mean that there had to be clear evidence that the sexual act occurred and that the child had to have known and had to have had the mental capacity to appraise the sexual act and knowingly consent. This case exposed a clear necessity to create greater specificity in the law to ensure that these cases are able to be prosecuted to the fullest extent, to hold these monsters accountable for these heinous acts, like in this case. HB 2761 makes it very clear that children, our precious children, my friends, neither have the capacity to, nor do they have to perform the sexual act agreed to in order for the state to prosecute and convict a person of compelling prostitution, of trafficking of persons under the penal code. HB 2761 explicitly ensures that this defense cannot be made again in court, and individuals like Mr. Turley are fully held accountable for their actions. I respectfully urge the committee to support this great bill, to protect survivors, to strengthen prosecutions, and to uphold justice in our state, particularly for the most vulnerable, our precious children. And with that, Mr. Chairman, I'll conclude my remarks. But again, we need to do better. We cannot tolerate these kind of monsters, and we need to be aggressive. So thank you all very much for allowing me to lay out this bill this afternoon.
Thank you. Thank you for bringing it to us. Any questions, members? Any questions, members? If not, at this time, the chair opens up for invited testimony. The chair calls Ryan Bounds. Ryan Bounds. Good afternoon.
Good afternoon.
You state your name, who you represent, and you may begin your testimony.
Thank you, Senator. My name is Ryan Bounds. I'm the Chief Prosecutor of the Special Victims Unit at the Williamson County District Attorney's Office. I'm here to represent the Williamson County District Attorney's Office. What my title means is that I'm responsible for handling adult sexual assaults and all forms of child abuse, whether that's capital murder of a child or aggravated sexual assault. I'm here for the bill. Frankly, you would think that it would not be a defense to say that a child could not consent to prostitution, and yet here we are, out of necessity, and I can think of no reason why we would not close that loophole so that no one is ever allowed to claim something so ridiculous ever again.
Amen.
That's all.
Amen. Thank you, sir. Thank you for being here.
Thank you for your testimony. Chair sees no other invited testimony. Chair closes for invited testimony. Chair now opens for public testimony. Chair sees no one registered. For public testimonies, anyone here present wish to testify on, for, or against House Bill 2761? Hearing none, the bill is left pending. You end up Creighton's? Yeah. I think we have time for one more. One more short one. House Bill 31. The chair lays out House Bill 3185, recognizes Senate sponsor Senator Creighton, and Senator Parker will go in his lieu of him to explain the bill.
Thank you, Mr. Chairman. Members, allow me to lay out HB 3185, sponsored by Senator Creighton. Cybercrime costs Texans billions of dollars annually, with ransomware, fraud, and identity theft affecting individuals, businesses, and public institutions alike. The FBI's 2024 Internet Crime Report ranks Texas as a top state for cybercrime complaints and losses due to the tune of $1.35 billion in 2024, which underscores the need for enhanced investigative tools. Current law restricts prosecutors' ability to issue timely subpoenas, delaying access to critical evidence in cybercrime investigations. These investigations are often hindered by the speed at which cybercriminals move assets and Internet service providers' data retention policies, especially when data is held by out-of-state providers. Criminals will often delete or alter critical information prior to law enforcement obtaining the records and prevent justice from being served on behalf of victims. HB 3185 addresses this issue by empowering Texas prosecutors to issue administrative subpoenas for cybercrime investigations, mirroring the current practice for Internet crimes against children, which has proven to be effective and legally sound. Within this framework, prosecutors can subpoena non-content records such as payment methods, IP addresses, and service usage data, while still maintaining the requirement to show probable cause for a warrant or court order to assess sensitive content information such as emails, account passwords, and browsing history. This process appropriately balances the need of law enforcement to access critical information during time-sensitive cybercrime investigations with protecting the privacy of private citizens. Thank you, Mr. Chairman and members, for allowing me to lay out the bill.
Thank you. Any question, members? If not, the chair opens up for invited testimony. Chair calls Nancy Aber.
Hello.
How
Thank
are
you
you
for
doing?
having me again. Nancy Abear, and I'm with the Montgomery County District Attorney's Office. I'm here for the elected official, Brett Ligon, testifying for and support of this bill. And I've been a prosecutor for 22 years almost, and I can tell you I am currently the financial crimes chief prosecutor over financial crimes and elder abuse. And this is an issue that has come up with this House bill often. And so this is a great bill that we are putting forth, and we appreciate you presenting it, Vice Chair Parker. I am board certified in criminal law, and what this bill does, as Vice Chair Parker indicated, is that it allows prosecutors to obtain administrative subpoenas, a process that's already utilized in the federal government, already utilized in internet crime cases, and why it's needed, as I alluded to earlier in my other testimony, is the speed in which cyber crimes occur, the law enforcement needs to keep up. And so what this bill allows is us to get an administrative subpoena so we can effectively battle romance scams, money laundering with drug deals. 419 has become a verb, which is in Nicaragua, the fraud provision in their law system, 419, is now a verb. You say, oh, they did a 419. So we need to be able to keep up with the current crimes that are going on and currently. This also helps our elderly, who are the targets most often in these type of crimes. So this also better protects Texans. And so what I would ask is that that you would vote favorably on House Bill 3185. It modernizes the Texas approach to cyber crimes. It revokes outdated statutory boundaries that take and delay prosecution of these cases and investigation of these cases. They may happen on a weekend, and we can't do anything because we've got to hunt down a judge to try to get a subpoena if we don't have the administrative process to try to go to these directly. So this also protects our elderly, who are targeted more than any other population when it comes to crimes such as fraud. And in fact, $716 million of cryptocurrency in 2023 was stolen from elderly victims going to the cybercrime process. And that's not easy for elderly people to go to these different kiosks and engage in these type of cyber crimes. So that shows you how prevalent this is, that there was that much fraud indicated against our elderly.
Thank you. Thank you for your testimony. Any questions, members? Thank you, thank you for being
Thank y'all.
here.
Thank you. Give Brett our best. Thank you for being here.
I see no one else registered for invited testimony. Invited testimony now closed. Chair now opens for public testimony. I see no one registered for public testimony. Is there anyone here who wishes to testify on, for, or against House Bill 3185? Hearing none, public testimony is closed, and we will hold the bill pending. Members, we were given an hour, and that hour is about up, maybe a little bit over. And we need to return back to the floor, and so we will recess to go back to the floor, and upon recess or adjournment, we'll come back and resume our hearing and hopefully get the rest heard out and voted tonight if we can. We have to 6:30? Well, if we have to 6:30, then we can keep rocking and rolling. I was told an hour. Yeah, yeah. Well, if not, okay, then if we have to 6:30, that gives us 40 minutes. Okay.
Knocking those three out. Who's got to go?
We're looking for maybe the longest one is going to be passed, and I think that we can do that in 40
This may
minutes.
be a fast one here too. I don't know. 306 just done.
We heard 37 and 30. 37, we're going to do that. We can do that in 40 minutes. Chair lays out House Bill 3073. The chair sends up the committee substitute for House Bill 3073. Is there any objection to adoption of the committee substitute for House Bill 3073? Hearing none, so ordered. Recognize Senator Paxton to explain the bill.
Thank you so much, Mr. Chairman. Thank you, members. I appreciate the opportunity to lay out House Bill 3073 by Representative Donna Howard. And members, you're familiar a little bit with the subject of this bill, Summer Willis, as we honored her on the floor just the other day. Members, the Sexual Assault Survivors Task Force in the Office of the Governor was created by the 86th Legislature to establish a survivor-centered, collaborative, and coordinated response to sexual violence in Texas. House Bill 3073, more widely known as the Summer Willis Act, is one of the task force recommendations for the current legislative session. Members, this bill passed the House with overwhelming support. House Bill 3073 closes the gap in the statutory definition of consent as it pertains to sexual assault or rape to help prosecutors hold perpetrators of sexual violence accountable. And it provides clear protections for survivors in circumstances not explicitly covered by current Texas law. First of all, the sexual assault statute does not currently provide a clear definition of consent. The current statute contains a long list of what is not considered consent with regard to sexual violence, but it fails to specify how consent is to be communicated or understood. House Bill 3073 provides clarity on the definition of consent by providing that it is to be defined with the same definition of consent that is used throughout the rest of the penal code, which is assent in fact, whether express or apparent. This means that consent, by definition, must be voluntary and active. By adding this definition, it means that our bodies will be granted the same protections already afforded our property in burglary cases. House Bill 3073 also provides that a sexual assault is without consent if the perpetrator knows that the other person cannot consent because of intoxication or impairment by any substance. Current statute only addresses if the perpetrator intentionally impaired the person without the person's knowledge. Under current law, those who are intoxicated of their own volition are not protected by this language. And additionally, current law does not protect a victim who is drugged by one person but raped by another. Such was the case for Summer Willis, after whom this bill is named, and she is here with us today to share her story with you. Mr. Chairman, the committee substitute removes language that is relating to the withdrawal of consent. And it removes language regarding if the perpetrator reasonably should know that the victim is intoxicated or impaired. As substituted, this provision simply addresses if the perpetrator knows that the other person cannot consent because of intoxication or impairment by any substance. Members, currently in the state of Texas, 2 in 5 women and 1 in 5 men have been sexually assaulted. I hope you will join me and the Governor's Sexual Assault Survivors Task Force in supporting this bill that will hold rapists accountable for their actions and protect future victims. There are some differences between the version the House passed and the committee substitute that we're hearing today, and I look forward to hearing the testimony around those differences. I appreciate also that Summer is back with us today at the Capitol to testify. Your voice matters. Thank you, Mr. Chairman and members, for your consideration of the committee substitute to House Bill 3073.
Members, any questions? Any questions, Senator Paxton? If not, the chair now opens up for invited testimony. The chair calls Summer Willis, Hillary England, and Ryan Bounds. Good afternoon. So for the record, we'll begin with you, and you state your name, who you represent, and you may begin your testimony.
Yes, my name is Summer Willis. I'm here representing myself, and I am in support of the bill. Thank you, Chairman Flores, Vice Chair Parker, happy birthday, and members of the committee. My name is Summer Willis, and I stand here before you today in support of House Bill 3073. I wanted to start off with gratitude. Earlier this week, you honored me with a resolution for my advocacy for survivors. Senators, the first time this bill passed the House of Representatives was just months after I was raped, 10 years ago. And for 10 years, it has been passed over, as if stories like mine and others didn't matter. But today is different, because today, this bill has you. You who signed my resolution on Monday, you who stood and applauded my story, you who walked across the room to shake my hand. Thank you for standing with survivors. Today I return to you not as an advocate or endurance athlete, but one of millions of survivors, one of 8.5 million survivors in Texas. I stand before you with the burden of a truth I never asked to carry. 10 years ago, I was a sophomore at the University of Texas when I was raped. I was handed a drink. I didn't know what was in it, but I do know that my last memory is not of consent. It's of running, of falling, of cutting my knees and my palms across concrete as I tried to escape the blur that was closing in. I woke up confused, naked, my body now a crime scene. The boy who raped me laughed. He laughed when he told me what he did. Days later, he and his friends documented in their fraternity newsletter, distributed like a trophy announcement. For 9 years, I buried this trauma. I buried it in classrooms in Texas teaching, under Peace Corps missions, under marriage and motherhood. I tried to fill the hole in my broken heart, but trauma is not so easily buried. It becomes a shadow that follows you. So in 2024, 4 months postpartum, I looked at my beautiful sons' faces. I decided that they deserved a woman who I used to believe I could be, someone who is strong and resilient and a fighter. So I started to run, and I kept running, 29 marathons in a year. I ran through pain. I ran for survivors. I carried a mattress for 26.2 miles to symbolize the burden that survivors carry. I crawled 13.1 miles on my hands and knees in Austin to show the brutal reality of moving forward through a system designed to break us. And in every city, I met survivors at playgrounds, on trails, behind podiums, and they shared their stories with me, and I began to run for them too. But here's the most devastating part. The rape that altered my life forever, the one that unraveled my sense of safety and trust and self-esteem, isn't even legally considered rape in Texas, because the person who handed me the drink wasn't the person who raped me. In Texas, if we don't scream, if we don't fight, if we have been drugged and made too incapacitated to say no, it doesn't count. Today could change that. Today I stand here for the girl that I was and for the countless men, women, and children across the state who deserve better. I stand here knowing that no matter what happens with this bill, the Summer Willis Act, I will never benefit from its justice, but that's okay, because this bill isn't for me. It is for every Texan who deserves to be protected from the horror that I endured. I've asked myself a question that no Texan should have to ask. Would it have been better if I was raped in a different state, like Oklahoma or Florida? Because at least they would acknowledge what happened to me was real, that it mattered, that I mattered. I'm sorry. Today, you hold the power to change that. Not just political power, but moral power. The kind that tells every survivor, spoken or silent, that their story matters. I'm not just asking for your vote. I'm asking you to answer this. Will Texas be the state that leaves survivors crawling? Or will you stand with us, So please define consent, define justice, define what kind of Texas you want to build. Thank you.
Thank you for your testimony. Members, any questions? Please state your name, who you represent, and you may begin your testimony.
Good evening. Thank you, Chair Flores, Vice Chair Parker, committee members. My name is Hillary England. I am the Deputy Director for Victim Services and Prevention Programs in the Office of the Governor's Public Safety Office.
Could you move the mic closer to your mouth, please? Thank you.
Would you like me to start over?
Please.
Okay. I'm here as a resource witness. I'd like to offer some brief remarks on the bill and the task force's original recommendations. In my role with the Governor's Office, I oversee the Governor's Sexual Assault Survivors Task Force, the Governor's Child Sex Trafficking Team, and the Public Safety Office Victim Services Grant Program Team. I've had the honor of working closely with the Sexual Assault Survivors Task Force for over 5 years, and have been closely involved in discussions regarding the task force's policy recommendations, including the consent recommendations the task force made in its 2022 biennial report to the legislature, and the consent recommendations that were made in its 2024 biennial report, which have been incorporated into House Bill 3073. The task force crafted these policy recommendations to help prosecutors hold perpetrators of sexual violence accountable and to provide clear protections for survivors in circumstances not explicitly covered by Texas law. Substances, most prominently alcohol, are often involved in adult sexual assaults. For absence of consent to be established, current statute requires a person to intentionally impair the other person by administering substances without their knowledge. House Bill 3073, incorporating the task force's recommendation, removes this requirement of intentional impairment, reflecting the reality of the circumstances of many adult sexual assaults committed in Texas where substances are involved. The task force also sought to clarify in its recommendation that consent is not present if someone knows or reasonably should know that the other person is intoxicated or impaired by any substance, is unable to give consent. HB 3073 also incorporates this task force recommendation. The reasonable person standard was included in light of multiple perspectives from task force contributors with deep expertise in the sexual violence field, including sexual assault advocates, prosecutors, law enforcement officers, and sexual assault nurse examiners. These contributors, alongside sexual assault survivors participating on the task force, have shared multiple examples of sexual assaults committed in Texas that follow a similar pattern. A person is drunk or impaired by another substance, most frequently one they have consumed voluntarily, and cannot consent to sexual activity. Some people black out or gray out, coming to during the sexual contact, unclear about what is happening to them. The person sometimes cannot remember any of the circumstances around the sexual contact because of their impairment. The reasonable person standard acknowledges that in these circumstances, it should be clear that the impaired person cannot give consent to the sexual contact. Another component of the task force's original recommendation incorporated in House Bill 3073 relates to the withdrawal of consent. This recommendation acknowledges that consent to certain sexual contact does not mean consent to all sexual contact. This recommendation preserves the autonomy and the right of an individual to change their mind about sexual contact, or to have a boundary they are placing around additional sexual contact respected. This recommendation, again, arrived at with considerable input from Texas sexual assault prosecutors, is particularly important for cases where the sexual contact may have begun as consensual, or where the individuals may be in an otherwise consensual intimate relationship, another common fact pattern. The Governor's Sexual Assault Survivors Task Force is committed to a vision for Texas that centers survivors' experience and leverages statewide experts to transform Texas's response to sexual violence. The task force is grateful for the legislature's trust, confidence, and support over the past several years. You too are part of this transformation. Texas has the right vision to continuously improve how we respond to sexual violence, and House Bill 3073 is an example of that vision in action. I appreciate the opportunity to provide these remarks, and I am available to answer any questions you may have about the House Bill 3073.
Thank you for your testimony. State your name, who you represent, and begin your testimony.
Thank you, Chairman. My name's Ryan Bounds. I'm the Chief Prosecutor of the Williamson County Special Victims Unit. I'm here representing the Williamson County District Attorney's Office. I am for the bill. I just wanted to take an opportunity to first state that I appreciate what this committee has done and where we're at now. Even as substituted, I support this bill. I believe that it is a change that has been needing to happen for a very long time. I believe that as it currently stands, because it requires not just that the person who administered the substance also be the person who committed the sexual assault, it also requires that they have the specific intent when they administer that substance, which is nearly impossible to prove as it is currently written. I have never charged it under that provision because it's almost impossible. So as the substitute indicates, for the person to know that the other person is intoxicated to the point at which they cannot consent is an incredibly important change that I fully support. That said, I also want to provide myself as a resource. These are the types of cases that I try. And I also support Senator Paxton's original version of the bill that included some of the things that the substitute did not. So if there were concerns or questions related to some of those items, I want to be able to provide the perspective of a prosecutor who tries these cases. I work with law enforcement to investigate them. I take them to grand juries. I make charging decisions. I try them to pettit juries. I also am the person who often has to make the phone call to a survivor of sexual assault as they cry on the other end and don't understand why what happened to them doesn't happen to fall into one of the specific boxes that our statute lays out. So anything this committee can do to close some of those loopholes that neglect to give justice to these survivors, I 100% support. And I'm here to answer any questions.
Thank you for testimony, Senator Parker.
Thank you, Mr. Chairman. Well, first of all, I just want to thank all three of you for your excellent testimony. Thank you for your excellence as a prosecutor and your passion for addressing these issues. Thank you for your leadership over the governor's operations and stopping all these activities across the state. Summer, thank you for being a courageous hero and standing up. It was very difficult for you to come forward all those years ago as a young girl and talk about what happened in order to make a difference in the lives of so many others permanently because of what you've done this last decade of your life and what you're going to do with this piece of legislation. So I just want to tell you how much we appreciate you. Thank you for your courageousness, and that we'll continue to work to celebrate survivors and to give people the support they need to make that transition from being victimized to survivorship. And you've done a tremendous job, and we're very proud of you. So God bless you and your family. Thank you all for being here.
Members, any questions? Thank you all for being here.
Mr. Chairman, would it be all right if I ask a question?
Please.
Thank you, Mr. Chairman, and thank you, committee, for your attention to this. Ryan?
Yes, Ryan.
Okay, thank you. Could you address the two differences, specifically why you believe they are important? The differences are the language around withdrawal of consent, and then the second difference, the words reasonably should know.
Yes. So I'll start with the first question. When it comes to the withdrawal of consent, it is I can tell you, a very common scenario where something may start as consensual, but for whatever reason, in the process of that sexual act, things take a turn. And what we tell our children, I have 3 sons. What we tell our children, right, is that no means no. And we tell them that you have that right. We ask this of juries when we pick these cases, and we say, when do you lose the ability to say no? And everyone in the jury panel always says, never. You always have the right to say no. But unfortunately, if we don't include something about the ability to withdraw that consent, we're not necessarily following through with what we tell our kids, no means no. And so I think that is the primary reason for the proposed change in the original bill. When it comes to the no versus reasonably should know, it's actually a subjective versus an objective standard, and it's probably inverted to what you would think. To say that someone knows someone's intoxicated is actually a subjective standard, because what you're looking at is what that person has in their mind specifically in that moment, whereas to reasonably know something, if they reasonably know it, it looks at a reasonable person standard. And that is a standard we use in things like self-defense. We use it in harassment cases or stalking cases, and the big difference between the two is proving what is subjectively in someone's mind versus proving it to a separate and objective reasonable person standard. Now, the thing about reasonable person standards is they're not described by the law. They really are up to whoever's the person that is receiving that information. So that would mean it'd be up to a petit jury who's receiving the evidence. It would be up to a grand jury who's receiving the evidence, whether it meets that objective standard or not. And so that would be the primary difference between know versus reasonably should know.
Thank you. Thank you, Mr. Chairman. I appreciate that.
Thank you. Any other questions, members? Questions? Thank you all very much for being here.
Thank you.
Thank you.
Is this the only invited testimony? Chair sees no one else registered for invited testimony. Invited testimony is now closed. Chair now opens for public testimony. Chair calls Bridget Lynch. Bridget Lynch. Sophie Centurioni. Samantha McCoy. And Latrice Godfrey. Latrice Godfrey. Good evening. We'll begin on my right, and if you'll just state your name, who you represent, your position on the bill, and you have 2 minutes.
Okay. My name is Latrice Godfrey, and my position on the bill is I support it. Good evening. I am standing before you today as a survivor of rape and as a voice of thousands of others who have been failed by a system that claims to stand for justice. On September 25th, 2022, I was raped in Tarrant County. I did everything right. I reported my assault. I submitted to a rape kit. I trusted the system. But my kit sat untested for 14 months. And when I finally met with the assistant district attorney, I was told no wasn't enough. I was told that because I was drinking, there was not much they could do because of how the current law was written. So just let that sink in. I said no. I was violated, but the law didn't see it that way because I was intoxicated. Let me be very clear. If I cannot legally drive while drunk, I cannot legally give consent while drunk. Texas already recognizes that intoxication impairs judgment when it comes to driving. Why doesn't our law recognize that intoxication impairs the ability to consent to sex? That is why I'm here to urge every single one of you to please pass the House Bill 3073. This is just not a bill, it's a lifeline. It's a declaration that Texas will no longer allow predators to hide behind alcohol or drugs. That being impaired doesn't make someone complicit. It makes them vulnerable, and the law should be on our side. The members of the Texas Senate, I urge you, and I say you guys have the power to change the lives with your vote. You have the opportunity, I'm sorry.
Go ahead and finish your last
I'm sorry.
sentence.
You have the opportunity to be remembered as a Senate that chooses courage over complacency. You have the ability to change lives. You have the ability to hear our voices. You have the ability to stand alongside of survivors. Thank you.
Thank you for your testimony. Your name, who you represent, position on the bill, you have 2 minutes.
I'm Sophia Rose Centurioni, and thank you so much, Chairman Flores and members of the committee. I'm here today as a 2025 Miss Texas's teen candidate, but more importantly as a survivor and advocate asking you to support House Bill 3073. I was sexually assaulted, and I didn't fight back, and I disassociated. Like so many survivors, my body shut down, I froze, I couldn't scream, I couldn't move, but that doesn't mean I gave consent. That doesn't mean it wasn't assault. That doesn't mean that it did not change my life. Right now, too many survivors are being failed by our laws simply because they did not fight hard enough. That idea is outdated, dangerous, and deeply unfair. HB 3073 matters because it reflects what trauma actually looks like and how the brain and body respond to fear. It sends a clear message that no is enough, and that freezing is not weakness, it is biology. I created my initiative RISE, which stands for Resilience, Inspiration, Support, and Empowerment, to help other teens understand their worth and their rights. I speak to young people all across Texas about consent, boundaries, and speaking up. But here's the truth. We cannot tell young people their voices matter if our laws don't back them up. We can't expect survivors to come forward if we keep asking them why they didn't scream or run. This is our moment to lead with compassion, courage, and justice, to stop whispering about assault and to start changing the system. Please support HB 3073. Survivors like me and countless others are counting on you. Thank you.
Thank you for your testimony. Your name, who you represent,
Thank you.
your position on the bill, and you have 2 minutes.
Hi, my name is Samantha McCoy. I'm in support of the bill, and I'm representing myself. My name is Samantha McCoy, and I am an appellate attorney here in Austin and a licensed therapist, but I am testifying today as a survivor of rape. For too long, survivors of sexual violence have faced impossible barriers to their pursuit of justice, barriers that embolden perpetrators, silence victims, and leave communities vulnerable. During college, I was physically beaten and violently raped while I was unconscious by an acquaintance. Within days after the attack, I would additionally find out that the perpetrator had filmed the rape and disseminated the video online and to people I knew as a way to further re-victimize me. Horrifyingly, the video plainly shows I was not moving, not responding to anyone or anything. I made the terrifying decision to report the perpetrator to law enforcement because I could not live with the thought of him harming someone else. Without any advocate or support person, I made a report, underwent a rape kit examination, complied with every request that investigators made, including countless and repetitive questions, and painfully having to wiretap the perpetrator without any guidance, or how terrible it would be to hear the person who had just beaten and raped me on the other end of the phone. Despite my efforts of undergoing a traumatic treatment by law enforcement, who asked me questions such as, if you were unconscious, then how do you know you didn't consent? In the end, the legal system turned its back on me. No charges were filed, no justice was served, and I was left with the fear, the knowledge that my attacker remained free, and the horrifying realization that the laws failed to protect people like me. House Bill 3073 strengthens the definition of consent to include when a perpetrator knows, and I strongly believe it should include when a perpetrator reasonably should know. It is common sense that a victim cannot consent because of intoxication or impairment by any substance. The language reasonably should know is essential, as we are all aware of how weak it would make the bill if we left the language as explicitly just knowing. Had this law been in place when I was assaulted, and with survivors that I now represent, I believe justice would have been within reach. Survivors deserve better.
Thank you for your testimony. Your name, who you represent, your position
Hi.
on the bill, and you have 2 minutes.
My name is Bridget Lynch. I represent the Safe Alliance in Austin, Texas. I am a sexual assault nurse examiner, so I give medical care and forensic care to survivors of sexual assault and sexual abuse. I'm going to read this because I'm nervous. Alcohol remains, I am in favor, sorry, I forgot to say that part. I'm in favor of this bill. Alcohol remains one of the primary weapons used by perpetrators to facilitate sexual assault. Whether survivors are socializing with friends, seeking safe transportation home, or simply trusting someone they believed cared about them, intoxication was weaponized against them when they were most vulnerable. This is a trigger warning. Our staff cared for a graduate student who attended what should have been a safe gathering among friends. After an evening that blurred his memory, he woke the next morning with physical evidence of anal assault and only flashes of traumatic memory. The fear and shame that followed was so profound that he could not sleep alone. He could not complete his master's exam. He could not return to work. His entire future was derailed by one night when he could not consent. We supported a young woman who made the responsible decision to call a rideshare rather than drive while intoxicated. The driver she trusted to get her home safely instead forced his penis into her mouth in the back seat of his vehicle. Her attempt to make a safe choice became the setting for her assault. We cared for another survivor who sought emotional support from someone she considered a friend during a difficult time. She had no memory of what happened between their conversation and waking up naked in his bed. She later discovered that the perpetrator had photographed himself urinating on her unconscious body. Her vulnerability was met with unimaginable violation. I've treated a young woman who was assaulted anally on a staircase during her first experience with alcohol at what should have been a safe sleepover with a trusted friend. Her experience with alcohol was exploited to facilitate her assault in a place where she should have been protected. These are not isolated incidents. They represent a pattern of predatory behavior that thrives in the absence of clear legal definitions and protections.
Thank you for your statement. Members, any questions? Thank you all for being here.
Thank you.
Chair now calls Dr. Larina, Dr. Masters. I'll just go with that. Is Larinia?
Lavinia.
Lavinia, okay, the R looked like kind of like a V there, but that's why I just went to Dr. Masters. Your name, who you represent, your position on the bill, you have 2 minutes.
Okay. I am Lavinia Masters. I represent myself, and I am for House Bill 3073. Thank you, Chair Flores and the whole entire committee for hearing us today. Thank you, Summer Willis and all the other survivors. I am also House Bill 8, the Lavinia Masters Act namesake. And I want to just dive right in. Sexual trauma can be debilitating for anyone. Whether male or female, the crippling effects can be the same, especially in how a victim internalizes and ultimately handles the healing processes in the aftermath. The offense can be rape, sexual assault, harassment, child abuse and or molestation, incest, drug-facilitated assault, intimate partners, sexual violence, or any other form of unwanted sexual violation. These crimes not only invade one's privacy and personal space, but also threaten their sense of safety and dignity. And in every case, they create a victim. And that's what happened to me. My first step on a college campus, the young man that was the dean, the top dean of students and everybody's hero, decided that I was not moving fast enough for him, so he drugged me with alcohol and he raped me. And although these offenses are committed against the victim, it is often a victim who bears the heavy burden of silence. Society frequently demands they keep quiet about the horrific acts committed against them. Many may ask, why would a victim keep silent? Especially when the silence spans years, even decades, like Summer. What are they hiding? What are they afraid of? Why didn't they speak up sooner? Are they protecting their perpetrator? These are the types of questions society throws at us survivors. Without truly understanding the weight of those questions, I can assure you they feel like daggers piercing both the story and the soul of the survivor. In the 1500s, a cruel punishment known as scolding or branking emerged in Scotland and later in England. The scold's bridle, also called a witch's or brank's bridle, was a device designed to punish and publicly humiliate those, mostly women, whose speech was deemed riotous or troublesome. This iron muzzle, I'm almost done, enclosed the head and pressed the bridle bit down on the tongue. Some versions even include a spike to pierce the tongue if the wearer attempted to speak. Women accused of gossiping were paraded through town wearing this device marked for humiliation and coerced into repentance. In some places, the bridle was permanently displayed in public as a warning to others. Tragically, the modern version of this punishment still exists, though now it's invisible. Today, many survivors of sexual violence walk through with a figurative bit in their mouths, afraid to speak out. They are made to believe that if they report the crime, they will face retaliation, public humiliation, or the destruction of their reputation. When we doubt or discredit a survivor's account, we are essentially calling their truth riotous. When we silence them with the threats of intimidation, especially when the abuser holds power or prestige, we are branding them troublesome. The real injustice lies in society's complicity.
Thank
Survivors,
you, ma'am.
okay,
Your 2
thank
minutes
you.
are up. I see you have 2 more pages and we don't have,
Okay,
you've gone
no
beyond
problem.
2 minutes.
But, so I ask you today to remove the skull's bridle by closing the loophole when it comes to consent.
And you're welcome
Thank
to submit copies of that as written testimony if you
Thank
would
you
like
so much.
to do so for the
Any
record.
questions? All right, thank you. I'm used to this, thank you.
Any questions, members? I see there's no more, anybody else registered for public testimony? Is there anyone here present wish to testify on, for, or against House Bill 3073? Hearing none, public testimony is closed and we'll hold the bill pending.
They send the sergeant.
What are they gonna do to us?
Chair lays out House Bill. Chair lays out House Bill 2017. Recognize Senate sponsor Senator Hagenbu to explain the bill.
Thank you, Mr. Chairman. I really appreciate you including this bill today, because at the last minute. Members, HB 2017 is a bill offered by Representative Gerdes on behalf of his constituent Grayson Davis, who was tragically killed by a drunk driver, illegal immigrant. And by the way, he was a good friend of Representative Gerdes and a heck of a good guy from everything I could tell, 29 years old. His killer had previously been deported following the commission of a drunk driving offense, clearly showed a pattern of extreme disregard for our laws. Representative Gerdes would like to name this Grayson's Law, by the way, if it passes. HB 2017 would ensure that undocumented immigrants who commit intoxication manslaughter, should they be held in Texas, have enough time to rehabilitate and guarantees that the criminal justice system has enough time to serve its purpose. HB 2017 increases the minimum sentence for illegals who have previously been convicted of a DWI offense to 10 years mandatory time served before they are eligible for parole. Taking this action will hopefully deter the tragedy that happened to Grayson Davis and his family from ever happening again. By changing the penalty structure of this bill, the bill from a minimum sentence to a first-degree felony, and ensuring the higher charge only applies to those with a prior drunk driving conviction, we tighten the scope of the bill and ensure that we protect Texas citizens from individuals brazenly disregarding our laws and place little value on the lives of Americans. Thank you, Mr. Chair, members, for hearing this and for your favorable consideration.
Thank you. Members, any questions? No questions? If not, now the chair opens for invited testimony. I see no one registered for invited testimonies. Invited testimony is closed. Chair now opens for public testimony. Chair sees no one registered for public testimony on House Bill 2017. Anyone present wish to testify on, for, or against House Bill 2017? Hearing none, public testimony is closed. We'll leave the bill pending. Are you going to do permission to keep going? You got to do Senator Parker's. He has 2306.
306. I'll do it. Okay, ready to go.
Chair lays out House Bill 2306, recognizes Senate sponsor Senator Parker, and Senator Huffman will explain the bill for Senator Parker.
Thank you. It's a straightforward bill. It adds the following trafficking-related offenses to the list of crimes in the government code that are not eligible for parole: trafficking a child or a disabled person for forced labor, receiving financial benefit from trafficking a child or disabled person, trafficking that results in sexual offenses against a child or disabled person. Under current law, individuals convicted of these offenses serve half of their sentence or 30 years, whichever is less. This House bill does not increase penalties. It simply ensures offenders of these particularly heinous crimes serve their full sentence by removing their delayed parole eligibility under Section 508 of the Government Code. Thank you.
Any questions, members? Now, Chair now opens up for invited testimony. As Chair sees no one registered for invited testimony, Chair closes invited testimony. Chair now opens for public testimony. Chair sees no one registered for public testimony. Is there anyone wishing to testify on, for, or against House Bill 2306? Hearing none, public testimony is closed. We'll leave the bill pending. I think that just leaves my three, right?
It just leaves your three.
Okay. So, Julie, would you like to
Meet me down.
knock mine out?
Finish here first. Yeah, just down to the bottom.
Go books. Whenever you're ready.
Chair lays out House Bill 1604 by President Metcalf, recognizes Senator Flores, lay out the bill.
Which one's 36?
1607.
1607.
Yes.
Thank you, Mr. Chairman. Members, House Bill 1607 would allow a person to operate their vehicle with one license plate located on the rear of the vehicle if the manufacturer does not include a bracket on the front of the vehicle must display a windshield insignia issued by the Department of Motor Vehicles. If a front license plate is not displayed, the driver must be in possession of the front license plate while operating the vehicle if it's not displayed. The DMV will still issue 2 license plates to motor vehicle owners. The owner of the vehicle would only be required to display one plate on the rear of their vehicle if no bracket bracket was included by the manufacturer. Under current state law, owners of cars and light trucks are required to display 2 license plates in front and back of their vehicles. 21 states, including all of our border states, already do not require you to place a license plate in the front of the vehicle, and many cars today do not come with a spot on the front bumper to affix a plate. This forces vehicle owners to drill holes in their bumpers in order to avoid receiving a citation. Often this causes thousands of dollars in damage, not only to the exterior of the vehicle, but destroy the sensors and cameras now found in all the newer vehicles. And with that, that's the layout.
Are there any questions of Chair Flores?
We're all.
You can ask me anything.
Oh, we don't want to ask anything. Nope, we're not going to ask you anything.
Okay, there's no question. We'll open invited testimony. Do we have any invited testimony? We don't have any invited testimony. Then we'll open public testimony. We have Scott Rubin, a public witness. Come up front, just identify yourself, who you represent, and your position on the bill. You have 2 minutes.
I'll be very brief. My name is Scott Rubin, Assistant Director for the Texas Police Chiefs Association. We're opposed to the bill. We think 2 license plates is the way to go for many, many reasons, and we see a lot of potential fraud if this bill passes by issuing 2 plates and only requiring 1. We think that's going to make a lot of plates available to be attached to other vehicles. Also, officers are not going to know which vehicles are equipped with a manufactured bracket and which ones are not. I'll very brief, I'll answer any questions. So.
Are there any questions of the witness?
No.
Chair has none. Thank you very much for your testimony. We don't have any other witnesses, so is there anybody else present who would like to testify for, on, or against House Bill 1607? 1607, if not, public testimony is closed, and we leave the bill pending. Chair lays out House Bill 1828 by Representative Orr and recognizes Chair Flores to explain the bill.
Thank you, Mr. Chairman. Members, House Bill 1828 would create a legislative leave pool program for the Texas Department of Criminal Justice correctional officers. Last session, a similar program for Texas game wardens was passed. Currently, state troopers are also allowed to pool up to 8 hours personal leave for legislative purposes. Correctional officers commissioned by the TDCJ would also benefit from having this opportunity be available to them. The bill would amend the government code to allow correctional officers to voluntarily transfer to a legislative leave pool up to 8 hours of compensatory time or annual leave per year earned by the correctional officer. The bill would require TDCJ to adopt rules relating to the leave pool. House Bill 1828 authorizes a correctional officer employed by TDCJ to only withdraw time from the legislative leave pool in coordination with and with consent of the president or designee of the association. The bill prohibits a peace officer from drawing more than 80 hours from the pool in a 160-hour workweek cycle and from drawing more than 480 hours from the pool in the fiscal year. Contribution of time to the legislative leave pool is on a voluntary basis only. There is no cost to the taxpayer. Happy to answer any questions.
Are there any questions of Chairman Flores? Chair is none. This time we'll open for invited testimony. Do we have invited testimony? There's no invited testimony. We'll open up for public testimony. Is there anybody present who would like to testify for, on, or against House Bill 1828? Okay, there's no one here that wishes to testify, then we'll call public testimony and we'll leave House Bill 1828 pending. The chair lays out House Bill 3664 by Representative Smithy and sponsored by Chairman Flores.
Thank you, Mr. Chairman, members. This is House Bill 3664 from Chairman Smithy in the House relating to the training of prospective grand jurors. House Bill 3664 amends the government code to require a prospective grand juror before the prospective grand juror may be accepted and impaneled under the Code of Criminal Procedure provisions governing grand jury organization to complete a training course regarding grand jury proceedings that is administered by the Office of Court Administration of the Texas Judicial System. The training course may be offered online and must include instruction regarding the following: the purpose and rules of grand jury service, the grand juror selection process, and grand jury procedures and deliberations. The bill requires OCA as soon as practicable after the bill's effective date to adopt rules as necessary to implement these provisions, including rules regarding the content of the training course. House Bill 3664 amends the Code of Criminal Procedure to require each person who is presented to serve as a grand juror to complete the training regarding grand jury proceedings described by the bill's provisions before a prospective grand juror may be accepted and impaneled. There is a committee substitute. I will have a committee substitute, but it's not ready at this time. But my intent with the committee substitute is as follows. 1, to require the Texas Judicial Council to be the rulemaking body, as the OCA is not a rulemaking agency. 2, to require transcription of the testimony of any witness appearing before a grand jury. 3, clearly provide that a case may be represented to a grand jury only if there is new evidence. 4, ensure Brady evidence is fully disclosed to the grand jury. And 5, align the effective date to move more closely aligned with the impaneling of grand juries to avoid confusion. Even though the companion was a lot more extensive as drafted, I've heard numerous concerns from my district attorneys and others, and my intent is not to add anything into the substitute other than what I have laid out. I will provide the substitute to the committee members when it is ready so that ample time is provided for review. And I'm happy to answer any questions.
Are there any questions? Senator Huffman.
Yeah, and of course, we don't have the committee sub, which I fully understand, but it makes it.
And we want to have it to review it very carefully.
Yeah, so I don't know if we'll have another opportunity to ask questions. I guess my question goes to the requiring that all the testimony be, did you say transcribed or just preserved? So does there have to be an actual transcription made available for everyone? Because I think that would be a huge unfunded mandate for local.
It would be require the transcription of the testimony of any witnesses before a grand jury.
Yeah,
is what
that
it would require.
It would be a lot. Yeah,
but
I mean for locals, I think.
Yes.
I mean, I see where you might want to preserve it in case, but there are so many of these cases that plead out, or there's no real need for them to be transcribed and so forth. So I'm curious how that would work.
And that's why we're having this hearing. So
Yes.
I want to make sure you all have enough time to look through it, and
Yeah.
if there's any changes that need to be made, or either on the floor or if it in the process.
And I didn't hear you say this specifically, but I know this type of bill has been heard before. So I believe there's a provision about what we used to call grand jury shopping. Where you don't get the result you want. Does it address that, or or does it do that?
It does not address.
It doesn't address that.
It does not address grand jury shopping.
Okay. All right. But I'll wait to read it, and then you and I can always chat about
Yes,
any
ma'am.
issues or questions I have. Thank you.
I hope we do.
Any other questions of Chairman Flores? Okay, at this time, do we have invited testimony? We do not have invited testimony. We'll open for public testimony. And we have Jarvis Parsons. We have Dustin Boyd, Philip McFurlow, come up front, please, and Sean Dick. We will start from the right. Just state your name, who you represent, and your position. You have 2 minutes.
Thank you, Mr. Chairman, for having me. Senator Hinojosa. Jarvis Parsons, registering against the bill. Brazos County District Attorney. This bill, while well-intentioned, I think may have a couple of problems. I'm just going to highlight one of them and just to make sure that I know you already know this, but there is already a mechanism in place for individuals or prosecutors who have a vindictive prosecution, who go after individuals maliciously. There's a mechanism in statute and in case law that allows a defendant to go to a judge and say, this is vindictive, this is outside the realm of justice. All of this bill would do is essentially, by barring the representation of evidence, would then hurt good prosecutors who see a bad prosecutor who's come in before them and has replaced them. And they have, for lack of a better term, canned cases that may be involving child sex abuse, murder cases, or adult sex assault cases, and say, you know what, those cases are very good cases and we should have taken them, and bars them from representing those cases to a grand jury, in effect giving a defendant more protection than they already have in statute, which is a lot of protection, and giving victims less protection. And so I think that this bill, I'm against that bill for that very purpose, that we already have a mechanism in statute and the status quo to be able to solve problems of vindictive prosecutors, but it takes away the rights of victims who may not have had a good prosecutor in the first place, and allows them to have justice finally. And with that, I will yield the rest of my time.
Good evening, thank you. My name is Dusty Boyd. I'm the district attorney in Corio County, that's in Gatesville. It's good to see you, Mr. Chairman. I am testifying against the bill. I do that with reservation, and I respect and appreciate and understand the idea of improving this system. There are two issues, Mr. Chair, as you've recited in the potential substitute. One is Corio County is a very small rural county. It's impossible to find a court reporter, let alone pay for one to transcribe every witness testimony that may be presented in front of the grand jury. That would be a hardship and a challenge for my county to engage with. So that would be one issue as you recited it. Secondly, and I don't want to be redundant with Mr. Parsons, as to the representment, my only concern with the language is it's a bit vague and ambiguous as it relates to who is the arbiter who decides whether there's new evidence or not. Because ultimately, it would have been the original grand jury that decided not to no bill to go back to decide whether there's new evidence or not. Otherwise, we'd be presenting either to the judge or to the new grand juror person to say, this is what we believe is the new evidence. So when might that be litigated? Before we present it or represent it? Or do we wait till after we present it, an indictment's returned, and then we're going to probably be forced into court with the defense attorney and potentially quashing the indictment based on representment and having to litigate it then. So I have a little bit of concern about who is the arbiter of who's deciding whether there's new evidence and to what degree that new evidence changes representment or not. I believe in grand jury. I know those who've been on the committee for a while have seen me before and know my history and my story with grand juries, especially when I was younger. I thank you for your time.
Mr. Furlow.
Thank you.
Thank you, Senator Hinojosa.
Senator, just a minute.
Sorry.
Senator Huffman.
Yeah, I think your testimony, sir, kind of went to my point about the concerns for the rural and smaller counties. And I'm just wondering, and I understand about transcription, I'm wondering if there's a compromise where you could preserve the testimony. I think that's the concern, is that, it's all done in secret and there's no way later to find out what the witness may have said or not said, or if there was any Brady material exposed or something. So would there be a way to maybe preserve it through recording or some way? And then if there was a concern later, then to have a way for a defendant to petition the court or something, for that to be transcribed and
I'm sure you're very aware of, there are motions the defendant can raise now if there's transcription or records to disclose that.
Do
So
they
that
camera
does exist.
things? Yes.
I don't want to repeat myself, but we are a very small county.
Yeah, I
And
realize that.
even with the dynamic and how we structure our control, the recording could be a challenge. I fight for every penny for my commissioner's court, and if we're doing it digitally, or if we're recording a grand jury, how do we do that? Do we start at the very beginning of the day and keep it recording all day long, and then have to go back and separate each case, or do we start and stop? To be clear, I understand the importance of protecting that information, but the logistics and the operations that go into that could substantially interfere with our
I
operation.
get that. I'm really trying to find a way to make this work. So I'm thinking, I think part of the concern is, I think, though I could be wrong, it's not necessarily the presentation to the grand jury, but a witness who may have been, presented. So Senator Flores, maybe the question is to you. Is it the entire proceeding that needed to be transcribed, including the presentation of the prosecutor and the grand jurors? Because sometimes they usually ask questions. A lot of times they have a lot of questions, right? Or is it if a witness is brought in to? Just the witness. But I know, like in Harris County, they record that anyway. But it's more I guess you're trying to get to the other counties.
The intent is the witness presentation.
Yeah.
only.
See, so that kind of limits it. So you would know when to turn on a recording. Again,
Only the witness
I'm trying to problem solve here because I know they're trying to make this
Can I
work.
respond to one point to that,
Yes.
Senator?
Yeah.
One concern that comes to my mind immediately is if the grand juror potentially knows that it's actually being recorded in any way, if it's being recorded versus being transcribed, because normally in a transcription it says grand juror question, right? But knowing that their voices may be recorded, might they not engage in questions that they
have
might?
a chilling effect, yeah.
Yes, ma'am.
Yeah, okay. That's all I have. I'm just.
Thank you.
Mr. Furlow.
Chairman Flores, committee. My name is Philip McFurlow. I'm the district attorney for the 106th Judicial District, which covers 4 rural counties between Lubbock and Odessa, where the sand blows and the tumbleweeds roam. I am against this bill. I have discussed it with 4 grand juries recently, last week, and it would have a significant chilling effect on their willingness to ask questions when they know those questions are being recorded. We have had numerous testimony about sexual assault cases and sexual assault against children cases. Those grand juries, when we present those cases, ask questions. Those questions, if they are transcribed and made available, if that's my daughter that's been sexually assaulted and a grand juror asks a question about the believability of the victim, and that is now part of a record that is going to be questioned, those victims go through so much to be able to bring a case to trial that if that's going to be part of a record that's going to be reviewed by the defense, that's going to be made public, that is going to have a significant chilling effect on both the questions and victims willing to go through that process, knowing that that is now something I have to tell them could come back and be a part of the record later. I think the recording, I had a case last week, sexual assault. 2 young people, it's not children, they're young adults, and the question of consent was very much a part of the case. The case was no billed. It is a very small rural county. I've dealt with the victim and the victim's family. They're very upset about it. If those questions and those discussions came out, it's a small rural county, I guarantee you there's going to be a papa asking some grand jurors questions. And so I do think the recording creates a significant chilling effect, and therefore I'm against the bill.
Thank you.
Okay, thank you. Mr. Dick?
Hi, my name is Sean Dick, and good to see you again, Mr. Chair. I'm the DA in Williamson County. I've been sort of a prosecutor for about 18 years of my career, a defense lawyer 11 years. I've been on both sides of grand jury. I've seen some good improvements in grand jury with getting rid of the pickup house system. So, but leave it to a lawyer. You know, I have to check yes, no, or on, and really I'm yes for training grand jurors. I think that's a good addition to what we have. So if you're just asking me if I'm for the bill as it came over from the House, I am. I do have reservations about changing something so important to prosecution and important to our criminal justice system. You know, a grand jury is not a sword. It's actually a protection for our citizens. And I'm worried that a lot of what we're doing might actually end up having a reverse impact. And you might end up getting people indicted that might otherwise be no-billed by a grand jury through some of these changes that we're making. I also have some concerns because we have this tension. We need to get cases into grand jury within 90 days or violent criminals can be released. But the more restrictions and the more impediments that we have to get a case to grand jury within those 90 days, it makes our job more difficult, and we will have more violent criminals released because we're worried about trying to get all Brady information or all recordings done or things recorded. So I am against any changes to the bill other than maybe a technical change to fix the training portion of it.
Okay. Thank you for testimony. Any questions of this group?
If I may.
Mr. Flores.
Thank you all for you know how I feel about you all, about district attorneys, and there's no intent here to undermine the way you do your business as far as to execute justice. At times there's some weighing of the scales of justice that people want to think that they want to get a fair shake, and that's what this is about. But that's the purpose of these hearings, is to be able to get your input. And tell me, hey, this, we don't like it, and this is why, and that's what we need to hear. That's what I need to hear all the time. I've worked with especially my DAs, and I get that input. You know how I roll, but
Yes, sir.
You know how you roll.
But this but this issue is something that is being discussed out there, and you know it, I know it, but hopefully at some point We file bills, and then we want to see what you think about them, and hopefully we come to where we have an agreement that's good policy, that still maintains the integrity of our legal system go all the way back to England and the basis of grand juries, and an American system that is still the finest in all of God's green earth. And so I thank you all for being here and your input, and it's well taken. Thank you very much. I respect each and every one of you.
Thank you, sir.
Thank you.
We have about 3 more witnesses: Audrey Lewis, Perry Thomas, and Jacob Putman. And we'll start with you, Ms. Audrey Lewis. Just identify yourself, who you represent, whether you're for or against the bill, and you have 2 minutes.
Thank you. Good evening, Senators. My name is Audrey Gossett Lewis. I'm the elected district attorney for Chairman Flores' district. I cover Atascosa, Wilson, LaSalle, Frio, and Karnes counties. So I have a very varied district, anywhere between 11,000 in one county and 55,000 in another. So my concerns are really with the committee substitutes. And they typically, you may have seen in the news, or maybe not, that I've recently indicted several elected officials in one of my smaller jurisdictions. And that is a result of a 3-year investigation by the Attorney General's office regarding election fraud. And I can tell you that 3-year extensive investigation, if we had on our grand jury people who just happened to be related or friends with those elected officials, to the point where we had a vote of less than 9, if I am not allowed to represent, there will be elected officials in my smaller jurisdictions who go without facing justice for crimes they commit. I'm thankful that in that county, the grand jury did the right thing, but it very well, and I made it very clear to my investigators, it very well could go a different way because it is a small community and everyone knows everybody. And so as a general rule as a prosecutor, I've been prosecuting for 25 years. I've prosecuted in Bexar County, prosecuted quite a bit over the state of Texas. As a typical rule, we don't represent cases. But I think if you make that a hard and fast rule, particularly in my smaller counties, that may mean that someone goes without being prosecuted that should be. And so I think that precluding that statutorily does not fix what the problem is. And I kind of understand, and I understand the reason and logic behind it, and I think it can be good and useful, but I think it could also hinder what would be very well and deserving prosecutions. Thank you.
And thank you for being here.
Mr. Thomas. No, go ahead, Mr. Thomas.
Senator Flores, members of the committee, I'm Perry Thomas. I'm the district attorney for the 33rd, 424th Judicial District, which is Burnett, Llano, Blanco, San Saba counties. We have a number of rural counties in our district. So, of course, my first concern is if people that testify before grand jury or members of grand jurors, if they've been recorded, some of my counties, it really is true. Everyone knows everyone. Mm-hmm. And so when they hear the voices of grand jurors questioning, I think they'll be afraid and have a chilling effect on their ability or willingness to ask questions in a grand jury proceeding. But my other concern, too, is the prohibition, possible prohibition against being able to represent cases to a grand jury. I've dealt with the grand jury recently that at first, they would not return indictments on cases involving strangulation where a family member was strangled. I don't know why that was happening. A couple of the people were very serious suspects, and I'm scared for the victims in those cases, and they would not indict. But over time, something switched, a light came on within the grand jury, and they realized this is a serious issue, and they began to indict those cases. And so there's one or two of the cases that I would like to possibly go back to the grand jury and say, would you like to take another look at this? I'm worried about the victim. This suspect scares me. Do you want to take another look? And so I think a complete bar of the ability to do that could endanger some victims in certain circumstances. So I oppose the bill.
Thank you, Mr. Putman.
Thank you, Chair Flores and members of the committee. My name is Jacob Putman. I'm the criminal district attorney in Smith County. That's Tyler, Texas, out in East Texas. I'm against the bill as proposed to be substituted. Thank you for the opportunity to speak. I would echo what was just said about the ban on representing cases. I think that's extraordinarily rare in any DA's office, but I have seen it happen where outgoing DAs who've been voted out by their constituents because they have lost faith in the current DA to then take friends of theirs to grand jury to get a no bill. Now, we're not banned from representing those now, but there's certainly a public appearance that would makes it look bad if the next DA were to represent those. If we were banned from representing those, that would allow outgoing DAs to intentionally seek no bills of people they want to protect from prosecution in the future. And I don't think that's a consequence that anybody wants to have. I would also add to Senator Huffman's concern about the recording of witnesses. If a witness says something exculpatory in grand jury, even though the grand jury proceeding is secret, 3914, the Code of Criminal Procedure, requires us to turn that over already to the defense. We would have to type up what we believe they said and turn that over, and we could lose our license if we don't do that. So that there is a protection there for that concern. This bill, or the proposed substitute, and I know other bills in the past, it seems they are well-intentioned and they want to protect defendants, and I understand that. That's part of our job as prosecutors, is to protect their rights. But they want to protect it by giving them certain rights at grand jury, recording witnesses' testimony, turning over Brady evidence, protecting them from representment. That's kind of a double jeopardy. What it's really doing is turning grand jury into a trial. And trials are long, and they're expensive, and they take a lot of time. And if we do that with our grand juries, DA's offices are not going to be able to move cases efficiently. They're not going to be able to meet those 90-day deadlines to make sure violent offenders aren't getting out. And so we'd ask that you not substitute the bill. We appreciate your time. Thank you for listening.
Thank you. Testimony.
Chairman?
Senator Flores.
Again, repeat what I said earlier. I respect each and every one of you, and a lot of my own DAs are here, and I wanted to hear what you had to say. You know, but again, the committee substitute is not finished yet, so your input is very important to us and to me. Thank you very much for being here.
Thank y'all very much.
Do you have any questions, anybody else?
We have one more witness, Shannon Edmonds. For the
Thank you, Mr. Chairman and members. My name is Shannon Edmonds, the Executive Director with the Texas District and County Attorneys Association. Testifying on the bill, this topic has been this is my 13th session. This topic has been front and center in this committee for 13 sessions. And it's natural to have issues with the amount of due process that is provided in the grand jury system. Other states who have raised some of the concerns that this bill purports to address in the committee sub, they do that by getting rid of the grand jury, going to a direct file system, and then everybody has what we call examining trials, where after someone's been charged, they can have a hearing in front of a judge who can decide if there is probable cause, what everything the witnesses say is recorded and preserved. That's how those other states handle some of the issues that you've talked about. We've had an opportunity to research what other states do. Most states use that model. Only about 20 states still use a grand jury and require all felonies to be presented to a grand jury. None of those 20 states that we know of implement or have on the books the provisions that are being, that were laid out, that we heard. And there's probably a good reason for that. So we're happy to discuss that option. It's been about 6 or 8 years since it was looked at by the Judicial Council. So that could be something to look at. But the difficulty with doing it in a grand jury system, it's not built to provide some of the due process that some advocates want. And that's why those other states have gotten away from it. And we're happy to explore that or answer any questions about that.
Any question, members? We really appreciate your testimony. Thank you so much.
Thank you.
Okay. Is there anybody present who would like to testify for or against House Bill 3664? If not, public testimony is closed, and we'll leave House Bill 3664 pending.
Thank you, Chairman Hinojosa. Members, if you all are ready, we can vote some bills out. You all ready? We got about 10 minutes. We can do it. Chair moves that House Bill 75 be reported to the full Senate with the recommendation that do pass favorably and be printed. Clerk will call the roll.
Chair Flores?
Aye.
Vice Chair Parker?
Aye.
Senator Hinojosa?
Aye.
Senator Huffman? Aye. Senator Miles? Senator King? Senator Hagenbu? Okay. 5 ayes, 1 nay.
5 ayes, 1 nay. House Bill 75 will be reported to the full Senate with a favorable recommendation. Chair moves that House Bill 108 be reported to the full Senate with a recommendation do pass favorably. Oh, we're going to hold this. See, hold on just a minute. Go back.
Sounds good.
Chair moves that House Bill 108 be reported to the full Senate with a recommendation do pass favorably and be printed. The clerk will call the roll.
Chair Flores?
Aye.
Vice Chair Parker?
Aye.
Senator Hinojosa?
Aye.
Senator Huffman? Aye. Senator Miles?
Yes.
Senator King?
Yes.
Senator Hagenbu? 6 ayes, no nays.
6 ayes, 0 nays. House Bill 108 be reported to the full Senate with a favorable recommendation, and then we'll go to the floor. Chair moves that House Bill 413 be reported to the full Senate with a recommendation do pass favorably and be printed. The clerk will call the roll.
Chair Flores?
Aye.
Vice Chair Parker?
Aye.
Senator Hinojosa?
Aye.
Senator Huffman? Aye. Senator Miles?
Yes.
Senator King? Yes. Senator Hagenbu? 6 ayes, no nays.
That'd be 6 ayes, 0 nays. House Bill 413 will be reported to the full Senate with a favorable recommendations. Senator King recommends House Bill 413 be recommended to the local and uncontested calendar. Any objection? Hearing none, so ordered. Chair moves that House Bill 1422 be reported to the full Senate with a recommendation that do pass favorably and be printed. The clerk will call the roll.
Chair Flores?
Aye.
Vice Chair Parker?
Aye.
Senator Hinojosa?
Aye.
Senator Huffman? Aye. Senator Miles?
Yes.
Senator King? Senator Hagenbu? 6 ayes, no nays.
There'll be 6 ayes, 0 nays. House Bill 1422 will be reported to the full Senate with a favorable recommendation and will go to the floor. Chair moves that House Bill 1871 be reported to the full Senate with a recommendation do pass favorably and be printed. The clerk will call the roll. 1871. 1871 by Shortner.
Okay. Chair Flores?
Aye.
Vice Chair Parker?
Aye.
Senator Hinojosa?
No.
Senator Huffman?
Aye.
Senator Miles?
I'm going to be adding an amendment to that, but right now, I'm voting yes. I will be exclude automobiles.
I'm sorry. You gonna add an amendment now?
No, on the floor.
Yeah, I'm just making a statement, sir.
Right.
So aye.
I'm an aye.
Okay,
But I'm going to.
great. Senator King?
Aye.
Senator Hagenbu?
Aye.
6 ayes, 1 nay.
6 ayes, 1 nay. House Bill 1871 would be reported to the full Senate with a favorable recommendation. Chair moves that House Bill 2073 be reported to the full Senate with a recommendation do pass favorably and be printed. The clerk will call the roll. 2073.
Yes, sir. Chair Flores,
Aye.
Vice Chair Parker,
Aye.
Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 7 ayes, no nays.
Be 7 ayes and 0 nays. House Bill 2073 will be reported to the full Senate with a favorable recommendation. Chair moves that House Bill 2348 be reported to the full Senate with a recommendation do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker,
Aye.
Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 7 ayes, no nays.
Be 7 ayes, 0 nays. House Bill 2348 will be reported to the full Senate with a favorable recommendation. Senator King recommends House Bill 2348 be recommended for local and uncontested. Any objection? Hearing none, so ordered. Chair moves that House Bill 2593 be reported to the full Senate with a recommendation do pass favorably be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker,
Aye.
Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles,
Yes.
Senator King, Senator Hagenbu. 7 ayes, no nays.
7 ayes, 0 nays. House Bill 2593 will be reported to the full Senate with a favorable recommendation.
There's a committee substitute on it.
Okay. Chair lays out House Bill 2761. The chair moves that House Bill 2761 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker,
Aye.
Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 7 ayes, no nays.
7 ayes, 0 nays. House Bill 2761 will be reported to the full Senate with a favorable recommendation. It will go to the floor. Chair moves that House Bill 3185 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker,
Aye.
Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles,
Yes.
Senator King, Senator Hagenbu. 7 ayes, no nays.
7 ayes, 0 nays. House Bill 3185 will be reported to the full Senate with a favorable recommendation. Senator King recommends House Bill 3185 be recommended for the local and uncontested calendar. Any objection? Hearing none, so ordered. Chair moves that House Bill 2017 be reported to the full Senate with a recommendation to do pass favorably and be printed. Clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker,
Aye.
Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles,
2017? No.
Senator King, Senator Hagenbu. 6 ayes, 1 nay.
6 ayes, 1 nays. House Bill 2017 will be reported to the full Senate with a favorable recommendation. Chair moves that House Bill 2306 be reported to the full Senate with a recommendation do pass favorably be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker,
Aye.
Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles,
Sorry, ma'am. What number?
2306.
Yes.
Senator King, Senator Hagenbu. 7 ayes, no nays.
7 ayes, 0 nays. House Bill 2306 will be reported to the full Senate with a favorable recommendation. And then we got to do my.
Yeah, but you've got it. You can go ahead and do all of those.
Sure.
I'm sorry, Madam Clerk,
Yes.
2017,
Yes, sir.
can we go back, please? Or can we go, cast my vote on that?
Yes.
That was the bill that we got at the very last minute, is that correct?
Yes, I think so. Yes. 2017 by Hagenbu.
Mm-hmm.
Hagenbu, that's 6 ayes, 1 nays. House Bill 2017.
I would like to change my vote to it.
Okay.
House Bill 2017, that vote changed, Senator Miles changed his vote to an aye, so that's 7 ayes and.
Ask if there's objection.
Is there any objection to his changing his vote? Hearing none, it's ordered.
Okay.
Ms. Alvarado.
3463.
Chair moves that House Bill 3463 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Yes. Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman. Senator Miles.
Aye.
Senator King. Senator Hagenbu. 7 ayes, no nays.
7 ayes, 0 nays. House Bill 3463 be reported to the full Senate with a favorable recommendation.
Okay.
So we have his mind left? Yeah. Okay, so I'm gonna have to hand that over to you now. And, well, we have West? Which one? 2854? Pending? I think it's pending. Well, we will not pend it. Well, that's what I'm asking.
The chair moves that HB 1828 be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles.
1820, yes.
Senator King.
Aye.
Senator Hagenbu.
Aye.
7 ayes, no nays.
There being 7 ayes and 0 nays, HB 1828 will be reported to the full Senate with a favorable recommendation. Senator Flores, do you wish this bill to be recommended for the local uncontested calendar?
Absolutely.
Hearing no objection, it is so ordered.
Members, thank you all very, very much. That concludes our business with Senator King.
Mr. Chairman, I just noticed that the official committee clock is running about an hour fast. I could get admin to come and fix that before. Okay.
And we can hang meat in here. It's cold.
It's cold.
Senator Miles, you have a question? No? Yes?
We're not, what's 2854?
28,
That's the
28.
one that DES is submission.
We're pending.
I believe it pending.
We're holding it pending.
I'll tell you.
Members, that's good. Any other questions, comments? Thank you all very much, and that concludes our calendar, and the committee will resume at the will of the chair.
Smart. Well, you need a relief from all the other